Hi guys. I was just studying about this very important concept of political science, that is due process of law, and I thought that I should share this with you guys. So basically, what due process means, it is an American concept, and this concept tells us about the relationship between citizens and American state, or any other state for that matter, whichever applies this due process clause in their founding, in their law of the land. What due process means is that what is the correct nature of relationship between state and the citizens which reside inside it. In order to understand this nature of relationship and the true meaning of due process of law, first we need to answer the question of origin of a state, because the way we approach to the question of origin of a state, that by default decides the nature of relationship between citizens and states. So, for example, in American tradition, when we look at the constitutional history of America, we come to know that America, previously it was a colony of British Empire, and 13 American states came together and fought for the Revolutionary War against Britain. In 1776, defeated Britain and got their independence. So this war was fought against a colonial state apparatus, and it was first the event which triggered this Revolutionary War in America was an increase in taxation. So clearly it is a no-brainer that American citizens at that time of Revolutionary War were very skeptic about the state authority, and they were influenced by these Renaissance and Reformation thoughts. So the two primary political thinkers that shaped the political ideologies of American revolutionary fighters at that time were John Locke from England and Montesquieu from France. What John Locke contributed in political theory was a concept of limited government, a constitutional government or a limited government, and how that limited government was to be realized. For this, Montesquieu came through, and he gave the theory of separation of powers. So in that separation of powers, he gave the theory that in a state, the three primary functions, that is legislative authority, executive authority, and judicial functions, can never be or should never be unified in one authority. So there should be a clear separation, and three different distinct branches of government should be formed in order to make sure that no particular branch overpowers the other. So there should be also a system of checks and balances over each other. So if legislative transgresses its authority, it should be checked by judiciary. If executive transgresses its authority, it can be checked by judiciary or legislature, and vice versa. So these two concepts, first of limited government or a constitutional government, and then this theory of separation of powers, are deeply ingrained in American political psyche. So while the Federalist Papers were being written in America in 1789, I guess, in Philadelphia Convention, so what they did was they tried to make sure that citizens of America remain primary, that their rights and their liberties are not transgressed by the state authority. So the primary objective of American founding fathers was to make sure that citizens' rights and liberties that they used to enjoy in the state of nature are protected in the state that they are creating as well. So they gave a Bill of Rights to Americans, and they separated the state authorities into three parts: legislative authority, executive authority, and judicial authority. What they did was they made judiciary the guardians of the rights of its citizens. So judiciary becomes very important in this sense. Now, before we come to this nature of relationship between citizens and states, we must understand that American political system firmly believes in contract theory of origin of a state. So in contract theory, it is the citizens which are primary. They were living in a state of nature, and in order to manage their common affairs, they came together and formed the contract among themselves, and through that contract, the state comes into being. So by default, if we believe in contract theory, it is the citizens who are primary and not the state. Citizens have rights prior to the state. Citizens have rights prior to the state. So state is not the authority which gives the rights to the citizens. Instead, state is the authority which protects the rights already enjoyed by the citizens. So even a state cannot violate the rights that citizens already have. A state cannot violate the rights that it has no authority to give to citizens. Since state has not given the rights, so it cannot violate the rights. It's as simple as that. Now, what happens is that since there are three organs of state in American political system: legislature, executive, and judiciary acts as the guardian or the mediator or the interpreter of this relationship between these two variables. That is, on the one side that is citizens, and on the other side there is state. So what the two other organs of the state does is that if a legislative authority makes a law upon which that particular law in any way violates the natural rights of citizens, then it becomes the duty of the judiciary to interpret the said law and see that that law should be in accordance with the primary contract that has been signed between the citizens and the states. And if executive authority transgresses its authority, and executive authority is considered with the laws that has already been passed by the legislature, so this due process is essentially divided into two forms. When it comes to legislative authority, it is called substantive due process, and when it comes to executive authority, it is called the procedural due process. So the responsibility of when it comes to judging the acts done by executive authority in the state, what judiciary does is that it only checks whether the executive has followed the already said laws and processes accordingly or not. And when it comes to checking the legislative authority's due process, it not only checks the processes that has been passed by legislature, it substantively checks whether the said law is in any way in contrast with the natural laws of the citizens, or the natural rights of the citizens, or the fundamental rights that has been guaranteed to the citizens. So if in any way a law passed by legislature is in contravention with the fundamental rights of the citizens, then it is declared null and void. So due process in American system has two types. First is substantive due process, that is associated with legislature, and then second one is procedural due process, which is mainly concerned with the executive authority. Okay, so this is the essence of due process of law that is prevalent in American political system. I hope this helps you guys. Thank you very much.